SJC-12307, Commonwealth v. Jorge Rodriguez-Nieves.
Okay, Attorney Schnipper, whenever you're ready. You're on mute.
Can you hear me now?
Yes.
Thanks so much. Good morning, Chief Justice Budd, Associate Justices. Welcome, Justice Wendlandt. May it please the court. I'm Merrick Schnipper for Jorge Rodriguez-Nieves today. The defendant was convicted of murder solely on the theory of extreme atrocity or cruelty. And today, I'd like to discuss with the court two issues, two discrete errors, one of which improperly strengthened the Commonwealth's extreme atrocity or cruelty case by heightening the evidence of the victim's conscious suffering, and the other of which removed from the jury's consideration the most mitigating evidence available to the defendant on that same theory, and discuss how the combination of these two errors rendered a first-degree murder conviction and a sentence of life without the possibility of parole inconsistent with justice. Now, the first issue is the prosecutor's non-disclosure of and capitalization on Genesis Diaz's non-disclosed testimony, which provided the Commonwealth's strongest extreme atrocity or cruelty evidence, and was the evidence on which the trial judge sent that theory of conviction to the jury. Our post-conviction investigation has shown that the victim could not have spoken the words Ms. Diaz attributed to him, but because the Superior Court—
When we look at this, we have a decision by the trial judge, and it really comes down to whether or not that testimony, if you assume it was erroneously admitted because you have your expert, post-conviction expert, calling that into question, it comes down to whether or not there'd be a real factor in the jury's deliberations. And here you have a finding by the trial judge that goes against you. We have to defer to him in this. Tell me why the trial judge was wrong.
Sure, I'll tell you, and there's two reasons he was wrong, one of which is very case specific. The other one deals with some larger principles of law. I'd like to take the larger principles first. The judge didn't even discuss the fact that there's strong evidence to suggest that this evidence was not simply undisclosed and late breaking, but false. So I've asked repeatedly for discovery, and I've asked for an evidentiary hearing so we can explore the extent to which the government knew or may have known that these words were probably not spoken, and the extent to which, despite that knowledge, the prosecutor planned to use this evidence in his case for conviction. So that's the big picture issue. The judge didn't mention the Nat Pugh issue at all. No discussion of the presentation of false evidence. With regard to the impact on the jury, I would say that the judge's own ruling during trial contradicts his assessment.
That's him saying that, you know, I mean, I get what you're saying, that it has kind of a visceral appeal to it, reaction, when you say that there was, you know, he cried out for his family and the defendant was laughing. But under our recent case, Castillo, there's probably sufficient evidence of atrocity, cruelty, given the force used and the manner in which that blow was struck, correct? Don't you think that if you took that evidence out of it, it still satisfies Castillo in our atrocity jurisprudence?
I mean, you'll probably notice from my briefing that I haven't specifically raised sufficiency of the evidence on that theory, and I'm not contending today that if you remove that, there's insufficient evidence to send it to the jury, although I think it's a very close question.
Right, so you have a comment by a judge where he cites the laughing and the crying out as a factor, but there's still sufficient evidence to go to a jury on atrocity, cruelty, correct? Even without that.
Fair enough, but what we have here is we have a harmless beyond a reasonable doubt standard based on a knowing and intentional due process violation by a prosecutor. We don't have a sufficiency analysis. This is a Chapman analysis where the court really—
No, the analysis is whether or not this is a real factor in the deliberations. And
however—
will you let me finish my question? Thank you. What you said was that the judge relied on that to let the case go forward. What I'm saying to you is there's probably other evidence that was sufficient for atrocity, cruelty. So again, address how that could be a real factor in the deliberations if there was sufficient evidence of atrocity, cruelty otherwise.
Well, because sufficiency doesn't command a jury finding on a specific point. And here, when the judge notes this is the most powerful evidence, or he's certainly channels it when he's talking about the sufficiency of the Commonwealth's case, which suggests the power that it had to anyone who would have heard it. What we've got here is a situation where the judge also found that the Commonwealth, he said there's finding of bad faith and a impact on trial strategy. What you have here is a prosecutor taking late disclosed, undisclosed, and quite likely false evidence, marshaling it at the very end of his presentation to the jury, the final piece of Commonwealth evidence that the jury is exposed to.
I'm not clear on that, Mr. Schnipper, and help me on this on the record. And I've read it, but I read it last week. When you go through the Commonwealth's closing argument, because obviously when we look to see whether or not something's prejudicial, the easiest thing to do, and you probably do it when you review cases, to start the closing argument. So what did the Commonwealth think was important? Here, the Commonwealth kind of dismissed that evidence given the impeachment of the witness. So what did the Commonwealth say exactly in the closing argument about about the statements and the laughing?
Sure. Well, with regard to the statement, the prosecutor says, with regard to whether Genesis Diaz, whether the victim, actually spoke those words, he says, you'll have to use your common sense. But he says, I suggest you can use your common sense to know that the person's trachea is not their voice box or their larynx, and that there's no evidence on how long it took blood to come up, block the larynx, and prevent this man from speaking. Okay, he makes that argument. My expert laid it out very clearly that there is absolutely no relation between transection of the larynx and the ability to speak. That is not dismissing this evidence. That is emphasizing this evidence and urging the jury to use its common sense, in fact, which is common sense that has nothing to do with the physiological reality.
Doesn't the prosecutor go on to say whether or not you believe Hennessy, there's enough here for extreme atrocity, cruelty?
I mean, he certainly does. He says you don't have to rely on that exclusively, but
He says whether or not she said it.
But that in no way suggests that he's telling them to disregard it. I mean, he says, yeah, whether or not she said it, after he tells them why they should believe that he said it. And with regard to the testimony about the defendant purportedly stepping to the side and laughing, that's his primary evidence of indifference to the victim's suffering. He says the fact that he turns and laughs just says it all. Again, I've asked the judge to allow us discovery in a hearing so we can hear about how much, when the prosecutor met with Ms. Diaz before trial to find out exactly how much did he look into whether other witnesses had seen this supposed behavior by the defendant. No other person.
Because it's the same witness.
It certainly is the same witness.
So, Mr. Schiff, this might depend, in response to Justice Gaziano's questions, on what standard we're applying here, right? And
yes, and that's why I'm asking for a hearing.
Yeah, so that's what I want to ask you about, because if your point is, well, I need this post-conviction discovery to get the reasonable likelihood of false testimony could affect the jury standard, which, considering both the laughing and the victim's suffering manifested by speaking and what he said, might make the difference. So tell me, where is it? I know you say the manner in which the case was presented. I'm having a hard time with it. Where is it that we've got the level of bad faith by the prosecutor, that this was all intentional? He knew what he was doing in order to be able to avoid certain expert testimony, put the witness on last, and prove the case to a moral certainty.
So how do I draw that conclusion from the existing record, or what do I hope to get from a hearing?
Where is there enough to suggest that you should get post-conviction discovery?
Okay, well, in the post-conviction discovery we were allowed to access to this point. We have the prosecutor's trial notes showing that him planning to use this non-disclosed testimony in his extreme atrocity or cruelty argument. We have the organization of his trial presentation, so this witness is presented last, and these comments that she makes are the last part of her testimony. So in other words, this testimony is given literally minutes within the Commonwealth completing its examination of its final witness. We have a witness saying, I came in last week to meet with the prosecutor. As of now, we don't know if that was on April 25th, 2016, several days before testimony started, or just the last day of the week after the medical examiner had been examined. We don't know whether the Commonwealth, because I mean, trial counsel at sidebar, when he's arguing against an instruction of treatment, atrocity, or cruelty, immediately says, given the other testimony of the blood gushing of this, there's no way this guy could have spoken. I took one look at this thing, and the first thing I did was call a pathologist. The prosecutor, you're telling me, didn't have reason to at least ask the medical examiner whether this was conceivable before he uses it as a focal point of both his evidentiary case and his closing argument? I think
You certainly have a discovery violation.
we
Right,
have
and
an existing discovery violation.
Well, and again, if you let me finish my question, you have a discovery violation, and one of the problems we have is that the defendant's trial counsel objected to hearsay and prejudice, but be that as it, the judge would have excluded it, but be that as it may, you've got a solid discovery violation. You think if there's further inquiry in this matter post-conviction, you're going to get evidence that it was knowingly done?
I think there's a strong chance that I will, yes. And I would love the opportunity, and just so the court is aware, a person in my position, meaning an individual who represents a criminal defendant in a case in which death resulted, is not permitted access to anyone from the medical examiner's office. The only way for me to know whether the medical examiner spoke with the prosecutor about this issue is to have an evidentiary hearing at which I can examine the medical examiner, at which I can examine the prosecutor and find out whether, given the glaringly suggestive suggestion in Ms. Diaz's late disclosed testimony that this is false, and that a person is going to spend his life without parole until the day he dies in prison, instead of being considered for parole, the only sentencing differential here, the idea that we are not permitted to understand what level of knowledge the government's agent had with regard to that testimony, I think is a serious, serious issue, and the court is here on the full case.
And the difference is, as opposed to a new trial for remedy for the discovery violation and the impact, if the judge was wrong about real factor, you could potentially get, if done in bad faith, a dismissal with prejudice, correct?
No, I'm not suggesting it. You mean of the indictment itself?
Yeah.
No, I'm suggesting that without this bad faith use of false evidence, the only available, the highest available conviction to the Commonwealth is second-degree murder. We have asked for relief in the alternative, either a reduction or a reversal of the first degree.
Wait. There's already sufficient evidence. You're not making a claim otherwise of atrocity or cruelty. If we agree with you, and I'm not saying we don't, if we agree with you that this would have been a real factor because, as you point out in your brief, this was so visceral. He's crying out for his family and the defendant's laughing. Take that away from the jury. We disagree with the trial judge. It now goes back for new trial. You're saying not only do I want a new trial, but I want a cabin at second degree if I find out there's bad faith. I don't get how one follows the other.
Okay, I've got a couple of different arguments in my brief. The entirety of a new trial and the entire indictment is based on the manslaughter argument of advance, which is separate.
Yeah, I'm not so sure that I thought mutual combat requires a fight.
I'm sorry.
I thought mutual combat requires combat, a fight.
That's right. I mean, so what I'm arguing is on the manslaughter argument is taken in the light most favorable to the defendant, as is required to view the denial of the manslaughter instruction. It's clear that he believed they were entering into combat that was going to be armed after initially the conflict looking like more like a fist fight.
But didn't your client, excuse me, didn't your client go back and get the knife?
Yes, he did. Or certainly the
do you have any-
evidence.
Are there any cases where that has been held to be manslaughter, where there's been a break in the exchange and somebody goes, gets a weapon and comes back?
No, there's not. And that's why, as I acknowledge, we're arguing for somewhat of an extension of the law on that principle. But I think that you can see from the context of the trial evidence that there was a strong belief. And of course, the victim also returned armed with a knife, although he didn't draw his. And
Right.
So
The only way anybody knows that the victim had a knife was when they cut his clothes off.
correct.
So your client, even in the light most favorable, attacks a guy who he thinks is unarmed, and the guy never draws a weapon.
Well, I don't think it's fair to infer in the light most favorable to him that he thought he was unarmed. I think he thought he didn't draw, because he talks about them both going back into the house and then coming back out. But I think that what your question...
Also, there's testimony that the victim doesn't want to fight, right? He said 2 times, I want to go to the parade. I don't want to fight, right?
That was the testimony, yes.
Yeah, the fight is the part of the mutual combat I'm not getting. But go back to the original premise, Mr. Schnipper, about your relief, and maybe you can't get 2 motions for new trial allowed, right? So if we agree with you on the real factor, you get a new trial.
Yes, we get a new trial at the very least on the first degree aspect of the indictment, and if the court feels that it impacted the murder decision itself, then yes, we get a new trial on both.
Right, and then and the only way it gets reduced to a second degree is if we buy your manslaughter argument.
No, it gets reduced to second degree if you find that the false testimony from Ms. Diaz was a significant factor in the jury aggravating murder to first degree murder under the extreme atrocity or cruelty theory, which is the only theory of conviction, as I mentioned, and this is the Commonwealth's strongest evidence on those points, or at least, as Your Honor has said, the most visceral evidence on those points.
Right, but notwithstanding the adequacy in which you don't, of the Castillo evidence on atrocity or cruelty.
Yes, as I point out, I think the extreme atrocity or cruelty evidence, primarily evidence of the victim's conscious suffering, if we take out this late disclosed indifference testimony, is remarkably similar to Castillo, and in my reply brief, I lay out some of the reasons and some of the evidentiary similarities. I see I only have a few minutes left. If I could move briefly.
Before you switch out of that, so if we don't agree that your client was entitled to a manslaughter instruction, what you also emphasize his upbringing and sort of his psychological problems. Does that? I'm just trying to figure out if say I agree with you that evidence about laughing and etc. Creates some doubt. I'm just still trying to figure out why it's not just a new trial remedy, as Justice Gaziano pointed out. Does that psychological evidence get you to a reduced verdict in combination with this error, or not?
What I've proffered to the court are really dual avenues of getting us to the same point. As I said, I do think there are arguments for giving the defendant an entirely new trial, but if we set that to one side for the moment, I think the court could look, as in many cases, the court has said, when we have a trial error that results in a first degree murder finding that's incorrect, but there is no real evidentiary flaw in the second degree murder finding, you can either just reduce the verdict now from your own position, or you can send it back to the superior court for a new trial solely on the first degree murder portion of the indictment. In other words, the Commonwealth would have the opportunity to make its case again that this killing was committed with extreme atrocity or cruelty, but only with properly used evidence. With regard to the mental state evidence that we have presented through the post-conviction forensic assessment, our argument is twofold. One is that this was the strongest evidence of mitigation on extreme atrocity or cruelty that was available to the defense, and the fact that it was left out certainly prejudiced him. And you can see from defense counsel's other work that he did pre-trial and trial, this was entirely consistent with the theory of the defense. He's seeking a manslaughter instruction based on how agitated and overly emotional defendant was. He spent quite a bit of time. Again,
I'm just trying to, I get your argument. I'm just trying to understand, doesn't that still come back to a new trial? Because it's ineffective assistance for not presenting that evidence, right? We can't use that absence of evidence to create a 33E reduction, can we?
Well, you can consider evidence that is filed in the context of a new trial motion in part of your 33E review. I discussed the Moore case and a few other cases in my brief where that certainly is within the scope of the plenary review that the court's going to undertake. I do think you can use it, and I used it for purposes of a 25B2 motion below. And the court can consider that type of evidence when it looks at the entirety of the case and decides, again, whether life without parole versus life with parole is more consistent with justice. I would say that when you look at the court's recent ruling in Castillo, you have a remarkably similar fact pattern here in which a single blow kills a person. The person lingers in pain, although not as long in this case as in Castillo, but in any case how much is that really a foreseeable outcome of the defendant's own acts, and how?
Property counsel, is Castillo a gunshot wound?
Yes, it is.
Yeah, and
To
so
the
this
body.
one was different in that the defendant pinned the victim down, held down his legs and arm, and then plunged the knife into his throat, and then the victim bled out.
He grabbed him by the shoulder and stabbed him. So it's a single blow. Obviously, it's a
Well,
more
But it's a lot different, right, in kind,
it's a more
right?
interpersonal act of violence, but
We
it's
were-
uses
we were careful,
less force
Castillo.
than a revolver. Sorry.
We were careful in Castillo to say single blows still can suffice for atrocity or cruelty.
Right, and although I think this is a weak extreme atrocity or cruelty case, you'll note that I have not mounted a sufficiency challenge. I made that decision notwithstanding the weakness of the evidence after a very thorough review of the court's
I'm sure.
cases on extreme atrocity or cruelty.
I'm sure.
In Castillo, we specifically said, though, once again, that the defendant doesn't have to intend to commit a murder in an extreme, atrocious, or cruel manner.
Correct. Understood, Justice Lowy. And I'm not suggesting that the court modify its jurisprudence to require that either. What I am asking the court to do, in addition to considering the impact of the missing evidence in this case, is to extend the law to simply require that in every case where any evidence of a defendant's mental state at the time of the crime is proffered, that creates an entitlement to a jury instruction on the sort of mental impairment aspect that the court began in Gould and has developed through Rutkowski and many other cases. Because as Justice Kant said in his Berry concurrence, as Justice Duffley said in her Riley concurrence, in enabling the jury to fully consider everything about the defendant's actions is wholly consistent with and will really support the community conscience function that really is what the extreme atrocity or cruelty prong of first-degree murder under our law is about. And that's really notably different from premeditation, where you have an additional mens rea component. Here, what you have is the jury assessing whether the defendant's conduct so violated community norms beyond, as the court has frequently said and said again in Castillo, beyond the just standard atrocity and cruelty of unlawfully killing another human being. Have you gone so far beyond that the jury should aggravate your sentence and require you to never be released from prison or even considered to be released from prison? I mean, that's the sole differential here.
Of course, the victim's pain and suffering post Castillo and the defendant's knowledge of it is much less important.
I'm sorry, I'm having a little trouble hearing you.
Well, the victim's pain and suffering is no longer one of the factors, and so the defendant's understanding of it is less concerned. For instance, the point in Castillo about, he's a bad shot, so the victim suffered more, is no longer something that's going to inure to the detriment of the defendant in an extreme atrocity or cruelty.
Well, as I understand Castillo, it still can be a factor if the Commonwealth shows that it was a reasonably likely, that the extended suffering was a reasonably likely outcome of the defendant's actions, and the defendant would have known that. So I see it as, frankly, a bit of the opposite, and just that you still can use conscious suffering as a factor, but only when that conscious suffering, as the court said in Castillo, reflects on the defendant's actions. It is not the product simply of chance.
Any other questions? Okay, thank you, Attorney Schnipper.
Thank you.
Attorney Wendell.
Yes, good morning, and may it please the court. Assistant District Attorney John Wendell for the Commonwealth. I suppose I might as well start with Hennessy's testimony and what precisely we're to do with that. I would like to start by addressing that sufficiency point and what precisely the trial judge said when he denied the motion for required finding. He did not say, this is your only evidence. He did not say, this is your best evidence. He said, what about this evidence? This was the evidence heard 5 minutes prior as...
Mr. Wendell, the big picture is whether or not we find the judge was wrong when we determined that this testimony would not have been a real factor, correct?
Yes, it is, Your Honor.
All right, and we have quite visceral and quite damning testimony where the witness says, I saw the defendant go over to the stop sign and laugh. I saw the victim cry out for his princess and for his family. How are we supposed to excise that from the jury's mind when they find atrocity or cruelty? Wasn't the judge wrong in this regard?
No, Your Honor, I think the best answer to that is the judge's own reasoning as to why it's not a factor. He said, you know, if that testimony comes in and then an expert comes in and testifies that he's drowning in his own blood and that's why that's impossible, that's simply not a factor. The reason that this kind of a wound makes this an extremely atrocious or cruel murder, it's multiple factors. I can get to discussing Castillo a bit later, but there's the extreme level of force, there's the conscious suffering of the victim, and under the Castillo analysis, this is conscious suffering that is reasonably foreseeable because it is a stab wound to the neck. If it is impossible for him to speak, it is impossible only because he is choking to death on his own blood. In those circumstances,
we see a lot of these cases, unfortunately, and the callous statement of a defendant in reaction, and then the victim's crying out in that emotional way, strikes me as something that would be particular relevance to a jury. When you look at these cases, and you know, the point is, I take it from Mr. Schnipper, that's why this witness testified last, and that's why it was a big part of the Commonwealth's case. So again, how do we just take that out of the jury's memory?
well, Your Honor, I guess the answer to that question is that I don't necessarily think there's evidence that this is why the witness testified last, because frankly, there's no evidence as to when the trial prosecutor learned of this particular statement.
But I guess, doesn't that dovetail into counsel's request for discovery on this issue? Why not give, given the consequences, why not give the defendant the discovery he's asked for?
Well, Your Honor, we gave discovery. We gave the...
No, but I'm talking about the second motion that was denied.
I guess the answer to that question, Your Honor, is that there's simply no prima facie showing that he's going to find anything else, anything to suggest that this was further bad faith than simply a failure to disclose despite knowing the duty to do so.
You can see it's a discovery violation.
Of course it's a discovery violation, Your Honor. We have a continuing duty. The only date available to us is April 30th, which was 2 days prior to testimony. If nothing else, the trial prosecutor was required to disclose this to defense counsel at 8:30 a.m. Monday morning, about 2 hours before the witness took the stand and testified.
No, the DA was required to give the defendant this information as soon as he learned it, not at time of trial. Correct?
Right. I'm simply saying I believe it's possible that the early morning on the 2nd may have been the first opportunity to actually provide it. I suppose it would depend on the trial counsel's availability over the weekend. To give it over the weekend would have been...
It wasn't something that was just, I forgot, because the DA learned this information, puts the words Canine next to it, and knows he has a home run, correct?
Well, except that the problem with that view of it is that attributes a certain timeline to when he writes these certain things. There's no way of knowing precisely when he wrote Canine next to this information.
Well, I think that
it was April 30th.
Right, and that goes to Judge Wendland's question, why not a hearing?
Because assuming that he finds this out on April 30th, as I say, April 30th is a Saturday. If he can get in contact with counsel on Saturday, he's obligated to do so.
What year is this? April 30th, what year?
2016.
Okay, so emails available, phones are available?
Yes.
Okay, so assume on Saturday he can reach counsel.
Probably.
Okay.
It's there was something one of the days about trial counsel that had a personal issue on a day off. I don't recall what precise day that came up, but yes, there is probable that the trial prosecutor could have given this information a number, it would be hours to days in advance, but there's still no evidence that this is when he decided to make this witness be the last witness. Hennessy's is an important witness, not simply because of this testimony. She's also one of the few witnesses who can testify to the stab actually taking place. In fact, I believe the only other witness, I think that's Carlos, testifies that
Can I ask you this, counsel, in analyzing whether or not this evidence would have been a real factor in the jury's deliberation, do we excise Genesee's testimony? It seems like that's the present assumption and argument, or is it a delayed disclosure case?
It would be a delayed disclosure case.
So the only analysis as to what is a real factor is the expert's testimony that the victim would have been choking on his own blood. You would still have Hennessy's information, right? Or testimony.
Well, I suppose that depends. But that is the claim made by trial counsel, is had I known this testimony in a timely manner, I would have asked an expert witness about this.
No, but the trial judge says, if I knew this was a discovery violation, it's gone.
Not quite, Your Honor. What he says is, if I knew this was a discovery violation, I would have looked into further.
I would have excluded the testimony.
That was a possibility. That was not a guarantee. He suggested that he would possibly do any of a number of things depending on what counsel had requested, up to and including that.
You don't need the expert. If this was just, if the judge knew this was a discovery violation, as opposed to the objection that was raised at trial, the judge said, I would have said it's over. You don't get this testimony in. Then you don't need the expert witness.
That is true. If this testimony is excluded, then the expert need not contradict it, obviously. But
it also starts with your discovery violation. That's the problem. So you're trying to have it both ways, because what you have is glaring discovery violation, and you want to maintain the verdict.
Yes, Your Honor. And well, fundamentally, there are two different. First of all, even when there is a discovery violation, the question is, what would counsel have done differently? And the possibilities are: A, counsel would have sought the assistance of an expert who would have testified he's drowning in his own blood, there's no way he can talk, in which case, as the trial judge noted, that's not really going to undermine the impact of what precisely this man is going through as he lays there on the pavement dying. Option number two, this testimony stays out. Well, in that case, we analyze it as if the testimony never came in. How much do we still have? And
well, but you want us to go even further than that. You want us to say, okay, there's a discovery, but we know there's a discovery violation, and you want us to sort of give the prosecutor the benefit of the doubt that it wasn't an intentional violation, so that, because that affects the standard review. You also want us then to sort of make the jury's thought process go away, which is this visceral testimony go away. So we got to decide like 4 or 5 things in your favor to affirm this, right? I mean, it's a confluence of, decisions that help you out, and you need each one of them, right? I mean, if we can't decide whether the prosecutor did this intentionally or not without an evidentiary hearing, right? If the prosecutor did this intentionally, the standard review is different, right? So we have to sort of decide that one in your favor. Then we've got to deal with the fact that the jury had this information, and then we've got to sort of figure out whether it would have made a difference, but we know the jury did have it, and it's powerful evidence, so it's messy.
Except that it's powerful, except that it's then dismissed by the trial prosecutor as, forget it, doesn't matter if it happened.
Why does he, I mean, if he goes out, if the prosecutor goes out of his way to put in this last minute information as his last witness, and brings it up, obviously the witness gets cross-examined and their credibility gets diminished. But the prosecutor is like making a lot of this, even though this comes in out of the blue at the last second. It just, don't we have to give a new trial here? I mean, I'd like to understand sort of how we not give a new trial on this point with all of these problems. Or is there, or do we have to give this evidentiary hearing and put your colleague and the medical examiner's conversation with the prosecutor in play?
Well, Your Honor, I think there were a few questions there. As far as why the trial prosecutor took the tactic he did, I suppose the answer to that question may simply be the impeachment. That I was not at the trial. I don't know precisely how her credibility came off, but the fact of the matter is he did make the argument that his comment about use your common sense to know that the trachea is not the larynx, that's a single paragraph out of an 8-page argument on extreme atrocity or cruelty.
Right. Isn't that just wrong? I mean, I'm not a doctor. I have some common sense. I have no idea if that's true or not. Isn't that another clear error?
Well, to say that the trachea is not the larynx, that's
You know,
an obvious statement of fact.
We've held in other cases, or other courts, or the appeals court has held that various bodily functions or things that can happen to the body in the course of a homicide or an assault require some degree of expert testimony, even things that are less complicated than this.
That's true, Your Honor. The other point about this paragraph, not only is it but one paragraph out of 8 pages and promptly followed up with but it doesn't matter whether he spoke or not, it's also a direct response to an equally problematic statement by trial counsel who says this isn't possible. There's no way for him to have talked because his larynx was transected. I'm sorry, his trachea was transected. That's the comment.
Isn't it apparently true that he couldn't do it?
It happens to be probable that trial counsel is the one who is actually correct, but to the extent that neither may make this argument without an expert, both of them made the same error. They both argued based upon information that if it must require an expert, then both were required to have expert testimony to have it. So the comment itself.
The fact that the prosecutor dismissed, believe it or not, that the victim could have spoken, isn't that somewhat diminished by the fact that really the powerful evidence here in terms of the Cunin factors was the laughter of the defendant? So whether or not the victim actually spoke was kind of an aside. It was powerful and visceral, but also the laughter of the defendant was critical for the prosecution.
And that is barely mentioned at all by the trial prosecutor. And again, it's similarly dismissed. He mentions the fact that there's some comment about maybe he went over there and laughed, but whatever that is, whatever happened, he dismisses that as much as he dismisses
what the prosecutor was doing was trying to preserve his own credibility with the jury, correct? Because we have impeachment by the defendant, which he shouldn't have had to have done, by the way. But we have impeachment of the witness by the defendant. Then it goes for closing argument. The prosecutor knows darn well, like any prosecutor knows, that their own credibility, or any trial lawyer knows that their own credibility is online or at stake when they address the jury. So that's why it's dismissed. But we don't know what would have happened if the defense attorney didn't impeach. That's the problem.
But
you want us to give him credit for running away from his witness who he shouldn't have testified.
Well, but the thing is, Your Honor, we're again discussing whether this would have been a factor in the jury's deliberations.
No, the best evidence you've got is that the trial judge agreed with you, and the trial judge was there.
Yes, to some extent, yes, Your Honor. But there's also the fact we're discussing whether or not this evidence would have been a factor in the jury's deliberations. The fact that the evidence was so thoroughly impeached that my colleague was like, no, whatever, forget that. That is equally relevant to this analysis, because all of the testimony was in front of the jury, I assume you're correct that he's moving to preserve his own credibility with the jury by dismissing this testimony. And to that extent, he's asking the jury, I know you don't believe this, so ignore it. And to the extent that he's doing that, that contributes in its entirety to the analysis that this would not have been a factor in the jury's deliberation.
Don't we almost have to, I mean, the way Justice Wendland summed it up earlier, we have to find that when somebody pins somebody down and stabs them in the neck, and they die this way, that's, regardless of what else came in, that's gonna be, everything else is harmless beyond a reasonable doubt, because that's extreme atrocity and cruelty. Don't we need to do that? Because we got a lot of bad stuff in here. We have to sort of be able to basically say, if you stab someone in the neck and they die in the pool of their own blood, they drown in their own blood, that's extreme atrocity and cruelty, regardless of these errors.
I don't know that I would agree with this standard of review, Your Honor, but I would agree that making such a finding would remove any issue that we would have here. Again, I've argued that the evidence of extreme atrocity or cruelty was overwhelming in this case.
I have to say, I really don't understand that. I think the evidence of murder is overwhelming, but the evidence of extreme atrocity or cruelty, if you excise the laughing and the last words before meeting your maker, I don't know if what you're left with is the strongest extreme atrocity or cruelty case that I've come across, recognizing that, you know, that's the nature of murder. That's what we don't mean by extreme atrocity or cruelty.
Well, Your Honor, it's not so much a question of, like, are there other cases where it may be even more obvious? Perhaps more stab wounds would do something to perhaps improve it. But the fact that it's a single stab wound is, that is not in and of itself so particularly relevant here, where the stab wound is strong enough that it goes literally all the way through his neck. There's a wound on this side of his neck, as well as the larger one to this side. This is a wound of extreme force.
As Mr. Schnippner said about 5 times, extent to the injuries, that's on your side. You don't have a sufficiency problem at all. I'm just saying, when you say the evidence is overwhelming, I'm not sure from what I've seen that reading cases that this is overwhelming evidence of extreme atrocity or cruelty. It's absolutely sufficient.
Well, I suppose reasonable minds may differ on the point, but I would suggest the nature of the wound, the amount of force required to inflict it, the simple fact of the matter, there is actually evidence of indifference aside from the laughter testimony. The fact is, the defendant just walks away. Whether he stops to laugh or not, he simply walks away from this. That is evidence of indifference. The fact that the victim probably drowned in his own blood, and that is testimony that comes from the medical examiner. He testifies that there is blood in the victim's lungs, that the victim would have been in extreme pain. And all of this is, even under Castillo, this is reasonably foreseeable, given the intimate nature of the attack, that it should be obvious that stabbing someone in the neck right through the trachea is going to cause them extraordinary pain, and it's not going to be a quick death. This is unlike Castillo, where we have, well, fundamentally, it's an accident. You shoot somebody, you expect them to die if you shoot them in the back. Castillo is, furthermore, it's in the middle of a brawl, so it's a very different circumstance entirely. Castillo is entirely distinguishable from this case. I would suggest, in the particular circumstances of this case, no other verdict would have been found based upon the particular nature of the facts, given that it is a stab wound to the neck of such extreme force. I see my time is up. If there are any further questions, otherwise I would rest on my brief.
Okay. Thank you very much, counsel. We'll take our morning break.
Thank you very much.